Good morning. Recently, one Satya murder case uh, was given much importance, and because there was some brutal sexual assault at Annamalai University, in order to gain over the political trend created by the opposite party, one of the ministers says, "See, we have rendered justice by giving death sentence to the accused who involved in that murder," as if they have influence over the judiciary. See, the judiciary independence authority that claimed by the minister is unwarranted, contemporaneous, whatever it may be. But what was the ratio of this sort of death penalties? See, some of the countries, almost all Western countries, wanted to eradicate, delete the punishment of death. Recently, Zimbabwe has passed a statute abolishing the death sentence. That is totally different, whatever it may be. What our court says is most important. That the case says recently on 16/10/2024, 16/10/2024, AR 2024, Supreme Court 5299, AR 2024, Supreme Court 5299, Chief Justice B.R. Gawai, Arvind Kumar, and K.V. Viswanath passed a judgment wherein they had this is case Eknath Kishan Kumbhatkar versus State of Maharashtra. They have categorically stated that the non-examination of independent witness may not be ground for disbelieving the prosecution case when eyewitnesses, particularly the accused wife herself, has stated that the accused has murdered her daughter, pregnant daughter, because she married a lower caste man. And the claim of the accused under 313 CRPC, a blind claim, there was no attempt to prove. All these cases, the punishment was held, conviction was held good, but so far death sentence is concerned. They say convict hailed from poor nomadic community. He had an alcoholic father and suffered parental neglect and poverty. He dropped out of the school when he was 10 years old and forced to start working to support his family, doing odd jobs. All efforts made by the appellant to bring his family out of poverty did not yield desired results. Neither the convict nor his family members had any criminal antecedent. It could not be presumed that convict was a hardened criminal who could not be reformed. Hence, it could not be said that there was no possibility of reformation, even though convict had committed a gruesome crime. Convict was aged about 30 years at the time of commission of the crime. The medical report of convict disclosed that he had speech issues and he had undergone an angioplasty apart from suffering from other serious ailments. The present case would not fall in the category of rarest of rare cases, wherein it can be held that imposition of death penalty is the only alternative. The conduct report from the prison disclosed that the behavior of the convict with everyone in the jail was satisfactory for the past 6 years. Considering these facts, even though the crime committed by the convict was unquestionably grave and unpardonable, death sentence was modified to 20 years of rigorous imprisonment without revision. This judgment was deeply discussed multi-number of times. Several other judgments are there. What will be the rarest of the rare cases? So I have gone through the Satya's murder case judgment. However, the judge blindly, without proper discussion of the ratios, comparing with the ratios of the facts of the case. simply held that it is the rarest of the rare case after all, district judge. But that is her independent judicial power and prerogative, statutory right to pronounce the judgment. But the ministers and state government claim that they got speedy judges getting the accused death sentence is unwarranted. This is my humble submission. Therefore, go through the judgment. It will be helpful, but it took much of time. He would have languished. Much. The judgment was 6/8/2019. 6/8/2019. After long years, he seems to have been exonerated from death sentence. That is up to them. Thereafter also, law of equity is there. State government, central government can exonerate him, commute the death sentence to. So many things are there. Whatever it may be. See, we are, our criminal jurisprudence is reformative, not retributive. Therefore, I hope hereinafter no ministers, political minister, that too claiming to be an advocate. I know he may be an advocate from Oxford University. That resulting all these things, always it happens. Ministers who do not have much legal experience are being allocated with the portfolio of law ministry. That is good. In Bharatiya Janata Party, one who was not at all an advocate, a real estate broker, was appointed as a legal wing president. All this happens. Politics. Best wishes. I am talking too much. Best wishes.